And good morning, everybody. The Center for Constitutional Rights is very pleased to announce a landmark decision in the Stop-and-Frisk case today. In this decision, we are asking the entire city of New York, and particularly Mayor Bloomberg, to do the right thing. There has been years of litigation. There has been 9 weeks of solid evidence. The evidence has been carefully considered by a judge, and the judge has determined that the stop-and-frisk policy is unconstitutional. The people have spoken, and the courts have spoken. And in fact, the courts have ordered a monitor and ordered a community engagement process. So it's not just the lawyers speaking, but these are community groups, religious groups, advocacy groups, grassroots organizations, groups concerned with public education, groups concerned with public housing. All New Yorkers will be at the table. So in thinking about that, the New York City Police Department now has to be part of the solution because the judge has agreed with us that it was a big part of the problem.
This is a historic and long overdue victory because what this court has confirmed today is something that many New Yorkers, hundreds of thousands, if not millions of New Yorkers, have known for many, many years. And that's that the New York Police Department has engaged in a widespread pattern and practice of unconstitutional, suspicionless stops and frisks and systemic racial profiling. Now this ruling is, as I mentioned at the outset, not only the product of incredible legal work, but it is really the product of an incredible effort on the part of the police accountability movement in this city over really the past 15 years. Going back to the 1990s, as many of you know, this problem has been with us for years, for decades really. This is not something new.
The Fourth Amendment requires that the police stops of individuals be based on individualized and articulable facts that the individual is engaged in criminal activity. We put on an overwhelming evidentiary case that hundreds of thousands or more of these stops in the past years have not been based on reasonable, individualized, articulable decision. Of the 19 individual stops that we presented at trial, the court found that 14 of them had constitutional problems. But this case wasn't just about those 19 stops. Between 2004 and 2009, there were 4.4 million stops in New York City. The court analyzed our statistical evidence as to those stops and found that there were widespread violations of the Fourth Amendment of the U.S. Constitution.